First thing on the agenda today will be bill introductions. Do we have any? Go ahead. Make sure you get with Michael after the introductions. Go ahead, do the first one.
Sure thing. David Sofer, Legislative Policy Director for the Kansas Department of Commerce. We have 3 bills to introduce today. First one would be the renewal, the extension of the Star Bonds program. So this would be 21 RS 0614.
Okay. Is there any objections to it? Not seeing any. It's introduced. Go ahead.
Perfect. The next bill would be the ability to allow for HPIP tax credits to be transferable. This would be 21 RS 0613.
Are there objections? Not seeing any. It's introduced.
Thank you. And the last one would be an expansion of the Rural Housing Incentive District to allow for vertical building on Main Street and allow for housing on the 2nd floor of Main Street buildings and up. And that one is 21 RS 0641.
Okay. Are there any objections? Not seeing any. It's introduced. Just make sure you get with Michael and he has all that. Okay.
Thank you.
Accept.
Good morning. My name is Eric Weisner. I'm the Executive Director of the Kansas Real Estate Commission. On behalf of the Commission, we have one bill that we'd like to introduce to close a loophole in our law relating to activities requiring a Kansas real estate license.
You have an RS? You don't?
I don't yet.
Okay.
Yes.
Any questions? Without objection, it's introduced. No objection, it's introduced. Do we have any other bill introductions? Okay, not seeing any. We'll go ahead and move on to our agenda. Chuck, we'll go ahead and start the hearing. We're going to jump ahead here. I want to go ahead and do the Senate Bill 10. Chuck, you want to give us an overview? We'll go ahead and start the hearing on Senate Bill 10 and give us an overview of Senate Bill 10.
Thank you, Chairman. Does the committee members have Senate Bill 10 before them?
We do.
Okay. And is it all right if I share my screen as part of the presentation?
That's fine.
Okay. So just to start out with, Senate Bill 10 or the Right to Earn a Living Act is designed to facilitate employment through an examination of agency rules and regulations relating to occupational regulations, occupational licensing, and examine those with an eye toward whether they serve the public health or safety or welfare, and reduce them as the bill provides. So let me share my screen here. And I would note that this bill came before the legislature last year as Senate Bill 391.
Did it pass out of the Senate? I thought it did.
I don't believe so, Chairman. I believe it, I don't think it got a hearing in committee, if I recall correctly. I'll check to make sure, but that's my recollection from looking at the record.
Okay.
I would.
Version of that bill. Can you check when you check it?
Yeah, I can do that. I would note, Chairman, that there was a fiscal note last year, just so the committee is aware of that. If you wish, I can send that to Michael if he wants to distribute it, or I can, show it on the screen, just so the committee is aware of that. So starting with the bill, the first part of the bill is a number of findings that the legislature makes as part of the Right to Earn a Living Act. First, you see there's a reference to the right of individuals to pursue a profession without excessive government interference. Freedom to earn a living is the best means for economic mobility. A reference to regulations that are too restrictive, they limit entry and reduce competition, and they've exceeded legitimate public purposes. A finding that the burden of regulation is borne by individuals outside the economic mainstream most heavily. And then a finding that it is in the public interest to ensure the right of all individuals to pursue their professional opportunities and provide the means for individuals to do that, and ensure that regulations of entry into professions are necessary and carefully tailored to legitimate health, safety, and public and welfare objectives. And that's a key phrase, sort of the core of the bill. So let's turn now to, I guess, what is really the core of the bill, and that is getting past the definitions here, which we will get back to in a second. And that's section 2 of the bill, the bottom of page 2. So you'll see there that section 2 sort of sets out the standard, and it really sets out what this bill is about. All occupational rules and regulations shall be demonstrably necessary and carefully promulgated to fulfill legitimate public health, safety, or welfare objectives. A couple of key phrases there. One, occupational rules and regulations. That's a defined term. It refers to agency occupational rules and regulations. And if we look up here in the definitions, first of all, we'll see that agency is very broadly defined. Any department, bureau, division, board, authority, agency, commission, institution of the state, any political subdivision, any city, county, or unified government, but it does not include the judicial and legislative branches. Occupational rule.
Are there any questions so far? Not singing? Okay, go ahead.
Occupational rule and regulation, if you look on page 2 there, is defined as any regulation, rule, policy, is my screen? Yeah, is my screen being shared? I just wanted to check on that.
Yeah, I mean, we're seeing your screen.
Okay,
Maybe we
very
ought to
good.
just move through and go to the testimony, and then if there's questions, we can come back and maybe, because I know Senator Hildebrandt's got to get back to his committee to chair. So maybe we can let his testimony go, and then if there's any questions, we'll come back to you, Chuck, okay?
Very good.
Thanks. Let's go ahead. The hearing's open. We'll start off with the proponents. Senator Hildebrand.
Thank you, Chairman Olson. Thank you, Vice Chair Stefan and Ranking Minority Olin. I think he's listening in, and honorable members for allowing me to testify. Thank you for fitting me in on a rush. I introduced this bill because I just got a lot of concerns. I had a lot of concerns from constituents about licensing and the overburdening of licensing for going to work. And, you know, sometimes, especially during COVID, you had issues with people losing their jobs, things like that. And some of these that we would consider kind of entry-level positions, you still have to have a license, you still have to pay a fee. And just to give you a little bit, you have my written testimony. I'm not going to read from it, but I do want to touch a couple of things. The first thing is 60 years ago, 1 in 20 American workers were required to have a license or pay a fee for their work, what they do for a living. Today, 1 in 4 Americans that want to work in the United States has to have a license and pay a fee to earn a living for their family. That is the main goal and objective, is to shorten that back. As the reviser had said in his explanation of the bill, the whole crutch, you're going to hear from many behind me that are going to oppose this bill because they're going to say it's more of a burden for them, or safety is going to be an issue, or it's going to cut into their authority. As legislators, it's our jobs to set laws and guidelines, and then we cede that over to a lot of the administration, and a lot of the agencies. But one thing to keep in mind as you're hearing their testimony, nothing here impedes the safety, the welfare, or the good of the public of Kansas. Matter of fact, it says they have to evaluate them and make sure that it is demonstrably necessary. So there are necessities for having a license. Give you a good example in healthcare and law. You have to go a lot of college, have to have so many hours as a resident if you're a lawyer, or if you're a doctor, or you're doing anything medical. This does not change anything like that. But what this does do is things that are entry level, if you're going to put on, just to give you an example, if you want to cut somebody's hair, you're going to take 1,500 hours before you can cut somebody's hair. Or there's other things that are a little bit more high importance, only have to take 200 hours, sort of like an EMT. Why is that? I think that's what I want to address with this bill. Hopefully you guys will evaluate it and put it into context, and I pray that you guys pass it out favorably for passage. And I stand for questions at the appropriate time.
We'll go ahead and allow them to ask questions of you because you got to go back. Senator Dahl.
Thank you, Mr. Chairman. Senator Hildebrand, 1 in 4 workers need license. Where's that statistic? Where do you get that statistic at? I mean, where I grew up in feed yards and such, they don't have licensing.
There was a couple of surveys that were done.
Entry levels I'm talking about.
I can get that to the committee. There's like 120 low-level ones that they consider. In Kansas currently, I believe 35% of that 100, it's either 102 or 120 that they define. Kansas requires 35% of those to have a license or pay a fee. And also keep in mind the state is not the only level of licensing and fees for professions. A lot of municipalities have them as well. So.
Okay.
Could I follow up with?
Go ahead, follow up.
Like roofing, you know, we have a hailstorm. You get all these roofers that come in, and a lot of them are qualified, you know, they come in from everywhere. If we don't see a license, how is the consumer protected without looking and seeing that this guy is qualified to do that work?
Currently, that's something that they would look at, but currently the Attorney General, they have to apply to the Attorney General and pay a fee to do any type of roofing work.
Well, would this take that away then?
No, it wouldn't necessarily
Roofer's
take it
not
away.
a low-level entry job.
What this would do is it would require them to look at it and does it, one, ensure that regulations of entry or professions are demonstrably necessary. So if they can demonstrate that it is necessary, it stays on. It just requires them to look at it and make sure that any fee or any license or any regulation that they're putting on someone to go to work meets that criteria.
Strom?
Thank you, Mr. Chairman. Senator Dole actually touched on the issue that I was going to bring up. Currently, I think contractors in a lot of municipalities are required to apply for a permit, usually, I think a fee of around $50 to be permitted to do roofing in that community. It would not remove those, but it gives the process to appeal those type of, is that correct?
That's correct.
Okay. Further questions? Senator Peck?
Thank you, Mr. Chairman. The reviser indicated that this is a bill that had been seen by the legislature before, and there was a fiscal note previously, but we don't have one. Do you recall, Senator Hildebrand, about what that fiscal note was?
We've got the reviser, or we got the fiscal note somewhere, but there's such, you know, looky here, guys. I mean.
Okay.
I know there was a fiscal note, and you know, take fiscal notes for what they're worth sometimes. A lot of times I've found out being in the legislature for new people, the higher the fiscal note means a lot of times somebody doesn't want that bill. it's not necessarily accurate, it's their best opinion. When you look at them, if you see FTEs, that they need FTEs to review their policy, they're supposed to be reviewing their policy anyway, so why do they need FTEs to review them again?
You read my mind, Senator, because I was going to ask your opinion of it, and I won't now because.
Thank you.
Chairman.
We'll locate the fiscal note. It's just, we've gotten so much paper in today. It's Senator Stephan.
Chairman. I did have the opportunity to review the fiscal note, and what was particularly remarkable about it was one agency said it cost a whole lot of money and time to do this, and other agencies said it wouldn't cost them anything. It was across the board, and I found that very compelling. Thank you.
To me, on the fiscal note, it's probably something they should be doing already, reviewing all these policies. I would think you would have this, if you don't review them every year, you'd have it cycled where all your policies, you'd review it every third or second, rotate them. But so I don't know about the fiscal note, but we'll get the fiscal note for everybody. O'Shea, Senator O'Shea.
Thank you, Mr. Chair. Who would be responsible for reviewing these?
Reviewing the licensure and
Yes.
regulations?
Yes.
The agency or department that's requiring it.
And so they would be given the outline of, is it safety, is it, and then they would just, who would hold them accountable to make sure they're.
There's a provision in the bill that if someone applies for a license or they see that it's unfair, it doesn't follow this, there is a process for them to go through that they can challenge it.
Thank you.
Okay, further questions? Not saying, thank you, Richard.
Thank you, committee, and thank you for your time. Thank you.
Okay, James Franco, Kansas Policy Institute. Right here.
Thank you, Mr. Chairman and members of the committee. Just start waving wildly if you can't hear me or something like that as we're going on. I will try to be brief. You have my written comments before you, and I'll just pull out a couple of things from that testimony and introduce just one additional piece of information that everybody is very well aware of, is how much the Kansas economy is suffering as we deal with these shutdowns and then ultimately the recovery from the coronavirus pandemic. And if there's anything that government can't control through this, it should be removing barriers from the folks who are most harmed by the pandemic itself, the shutdowns and those sorts of things, to be able to grasp the bottom rung of the economic ladder. And that's what this bill attempts to do. For too long, occupational licensure, despite having the best of intentions of the people implementing the licensing regimes or reviewing them and administering them through the executive branch, has ultimately made it harder for many people, the most at-risk Kansans, to find the opportunity to work. It's what Senator Hildebrand just discussed about entry-level positions obviously suffering the most. And this is a bipartisan recognition. In my testimony, I have references to 3 different studies, one from the White House under President Obama, and it, in part from the executive summary, says, too often policymakers do not carefully weigh these costs and benefits, that being from occupational licensure regimes, when making decisions about whether or how to regulate a profession through licensure. The Brookings Institution, another center-left organization in DC, has written similar things. Kansas City's Hoffman Foundation has talked about the importance of licensure reform as a way to kickstart the COVID recovery. And then if the committee's interested, I could provide studies from center-right organizations, from the Institute for Justice, Cato Institute, Foundation for Government Accountability, and a variety of others making those same points. This is about controlling the things that the state can control as we recover from COVID in the near term and longer term, about trying to make economic opportunity more available for Kansans. So with that, thank you, Mr. Chairman. Thank you. I stand ready for questions at the appropriate time.
Hold questions till the end of the proponent. Elizabeth Patton.
Thank you, committee, for the opportunity to testify. Thank you, Chairman Olson. I am Elizabeth Patton. I'm the State Director for Americans for Prosperity, Kansas, and just want to go over some of the same things that Senator Hildebrand talked about. So not to try to be redundant, but just wanted to add some extra emphasis on a few of his points that he made. But he referenced the study from the Institute for Justice and a few other organizations that have surveyed over 102 low to moderate income occupations across all 50 states. And of the ones that Kansas licensed, we're looking at a lot of these requiring over 200 calendar days of training on top of fees and other requirements just to obtain permission to work from the government. So 28 of those licenses that we're talking about here in Kansas were enacted between 1993 and 2012 alone. So that is just a small window into the picture of these are a lot of recent regulations that haven't been on the books for a long part of history to demonstrate, in our opinion, ultimately their value in a lot of instances. Because you see so many differences between the 50 states, you have really no evidence, and especially these low to moderate income professions that we're talking about in this study, that we are providing consumer protection. Instead, it's really demonstrating to us that a lot of these rules, not all of them, but a lot of them are not about consumer protection. They're about protectionism for the industry and eliminating competition or becoming barriers to entry for a lot of these low to moderate income workers, making it difficult for them to get back to work, making it difficult for them to provide for their families, making it difficult for them to change careers. One of the other points I wanted to make is that I do have a study from Mercatus that talks more about that in greater detail. So if the committee would like additional data on that, I would be happy to submit that. In addition to my written testimony, I don't believe that I referenced that in what I submitted to the committee. But the point I really want to make today is that a review bill such as this one requires our state to look introspectively on where we have inconsistencies or perhaps overregulation to barriers. Overregulation or barriers to entry. You know, we're not up here saying that every single license and regulation needs to go away. That's not the purpose of this bill, but this bill does require us to make sure that we don't have something on the books that is unnecessary or frivolous. For some Kansas specifics, I want to point out that we are one of only 4 states that require a license for psychiatric technicians. For another example, animal breeders pay the highest fees in the entire nation here in Kansas. Estheticians have to complete 233 days of training here, which is over 100 days more than the national average. We require licenses for hair threaders who don't even have a class for that in any cosmetology school in the entire state of Kansas, and yet they're required to get over almost a year of schooling and thousands of dollars in costs to obtain a license for something that they didn't even take a class for the occupation for which they're obtaining a license. Another example is EMTs have 35 days of training, but in Kansas, manicurists require twice that and barbers 10 times that amount. So again, there's been scant evidence that stricter licensing actually relates to consumer protection. Those are just a few examples. I could go on, but I wanted to highlight a few of those top ones. And our opinion is that SB 10 ultimately would provide new opportunities for Kansas agencies, lawmakers, and most importantly, Kansas residents to remove overly burdensome and unnecessary occupational restrictions that ultimately undermine opportunity for our state. I've mentioned this in testimony before, but Kansas has been in the top 10 for outward migration for many years, and we are looking at policies that attempt to change that so we can be a state that is open for business, open for jobs, open for success. And we stand in strong support of this and other occupational licensing reform efforts, and we urge lawmakers to support this measure. Thank you. I'd be happy to stand for questions.
Thank you. We'll hold questions to then. Stephen Green.
Afternoon, or good morning, Chairman Olson, Vice Chair Steffen, Ranking Minority Member Holland, and members of the committee. My name is Steve Green, and I'm on behalf of the Opportunity Solutions Project. We are in support of Senate Bill 10. I've already heard some merits of the bill that are part of my testimony that you could refer back to. And so I'm just going to highlight a few things that we think is important about this bill. So by design, occupational licensing is made to protect consumers and ensure quality. But experts from both sides agree that some of the occupational licensing standards have drifted from its original purpose. We all know that competition is good. It allows lower prices, raises quality, and drives innovation. Unfortunately, Kansans and other states pay the price when regulations make it more difficult for someone to enter the profession, and that's why we support something like Senate Bill 10. This bill does that by requiring each licensing agency to take inventory of its occupational regulations and licenses to determine whether they are necessary for maintaining public safety, health, or welfare. It includes sort of guiding questions for each agency to determine whether they should repeal or modify a regulation or make a recommendation for the legislature. I think a meaningful overview and review process is long overdue in Kansas. We talk about other states who have followed suit. In the testimony, Arizona, Mississippi, and Ohio. However, I'm just going to highlight Nebraska. So my most recent role was a part of the Department of Health and Human Services at the state of Nebraska, and as part of a sort of a code agency for an executive order under Governor Ricketts, we actually had to reform and review all of our regulations that we had on the book. So for my division of Children and Family Services, that was 119 chapters that we reviewed. And just the highlight sort of the benefit. I can speak to that benefit. So the overhaul really helped in improving outdated regulations, creating a greater sense of stakeholder input, and improving public trust in a process that can appear for some to be cumbersome and full of red tape. So we support Senate Bill 10. Again, I want to thank you for the opportunity to testify as a proponent, and I will answer questions at the time that you're ready.
Okay, are there any further proponents? Okay, questions for the proponents? Yep, Senator Dahl.
Thank you, Mr. Chair. Stephen.
Yes, sir.
First one, you said something that interests me. You said that you were in Nebraska and they did a overview of all the regulations and everything. We didn't need legislation for that, did we? Nebraska did not pass legislation.
Can you stand up here?
I just wanted you to get exercise.
So in Nebraska, it was through an executive order in 2017 by Governor Ricketts. However, there has been several pieces of legislation in Nebraska focused on occupational licensure reform that the Nebraska unicameral took up most recently last year as well. I think related to audiologist was that specific reform, wanting to reduce the amount of training for somebody to receive that license.
Go ahead, follow.
So what I guess I'm asking, because what you're asking, we have too many rules, too many regulations. I agree with that completely. Couldn't we do this without legislation? I mean,
I can't speak on behalf of the governor of Kansas and what's possible through executive order. I can kind of rely on the experience I had in Nebraska. I'm sure it's possible. I think what's helpful is at least this is a helpful framework for reviewing those regulations with that every 5 years. And then just having those sort of codifying questions that need to be reviewed on a regular basis because of just the natural churn of state employees. It allows sort of to take a fresh look at the bill.
Go ahead, go ahead.
and this, Liz, maybe you could answer this, maybe, is what is considered low to moderate income? What's the?
I'm going to defer to Liz on that one, sir.
Any other questions? I know after you've asked too many, no, your quota's up. No.
We'll verify this with the study. I was trying to pull it up just to make sure I'm correct, but we're typically looking at occupations that are typically under about the $75,000 threshold. But I'll just double check the study to make sure I'm accurate on that, and I'll let you know for sure.
Elizabeth, we did a few years ago, worked on some legislation at Fed and state for people coming out of prison, trying to get their trying to figure out if they could get licensed, and they go take classes, all that. I see this as a lot of similar. I mean, we've got a lot of laws probably on the books for the last 100 years that we might not have cleaned, maybe some of them need cleaned up. We're not talking about doctors and lawyers and certain people, but are there, maybe going through and taking a look at the statutes?
There absolutely
clean 'em
are. I
up?
mean, there's definitely, I highlighted a few of them in my testimony, and I can provide more to the committee, but there are definitely plenty of rules on the books that need to be cleaned up related to the regulatory statutes on occupational licensing in Kansas. We see that over and over again. We can be better. We can be a more competitive state, and we can improve our economic standing, I think, as well by doing so.
Okay. Other questions or comments? Senator Stephan?
Chairman, wouldn't it be just as important to see the regulations cleaned up as see the laws cleaned up? Doesn't that part and parcel? If you clean up the laws, doesn't mean you're going to get your regulations cleaned up.
I mean, that's fair enough. I think this is a comprehensive issue that we need to take a look at, and part of our legislative agenda as a whole, and we just testified yesterday as well on SB 34. We're just trying to take an opportunity. Other states have done it as well, but you've seen such a significant even economic boon for states that have taken the time to review their laws and their regulations and the restrictions and things that are in place that maybe are outdated or are not serving the purpose that they originally intended, or could be removed altogether. And we don't believe in many of these cases, this bill addresses it specifically, that the point is to ensure public safety and welfare. What we're looking at is those that are on the books that are not serving that purpose and are adding fees or barriers to entry for folks to get back to work, and that can be said for, anyway, I know there's stuff on the books and the laws in addition to the regulations that could be addressed as well. That answers your question.
And there's probably duplications too that probably could be streamlined.
Sure.
Senator O'Shea, it's going to take me a while to get all these
That's all right.
names out. I got them all in my committee.
Thank you, Mr. Chair. I'm still trying to understand if the agency is asked to review this, what is the agency's incentive to change? And who's holding them accountable? And what is their...
I think that's ultimately the reason for the legislation, is because, making a request of an agency. I mean, so for example, we've seen that with requests from like legislative post audit, for example, or, does something we have on the books kind of actually require the introspection, or are we making a request that doesn't have the teeth in it to make those changes? I'll give another example of one of the reasons why, not to be off topic, but that we are supporting a related occupational licensing bill that's a different policy than this, but in the same vein, where there was a law put on the books in 2015 that ultimately wasn't enforced or wasn't enforceable, and we're back here now looking at an opportunity to not only clean it up, but perhaps expand it to make it more efficient and make it actually policy that works. Because to your point, we're trying to, just because you have something on the books in one way, or maybe if you make the request, we're trying to make sure we're actually have policy that is effective.
Go ahead.
Well, thank you. So the report would help us see where there may be gaps or inconsistencies, and then would allow us to make more informed decisions about policy and legislation.
That's
Okay.
the intent of the bill.
Okay. Thank you.
That's
Other questions or comments? Not seeing any. We'll move on to the opponents. Larry Carnes.
Morning, Mr. Chairman, members of the committee. My name is Larry Carnes. I'm the Executive Director of the Kansas Board of Technical Professions. Technical Professions licenses professional engineers, professional architects, professional geologists, land surveyors, and landscape architects. We license approximately 30,000 individuals, and about half of those are people who live out of state that have reciprocal licenses to practice in Kansas, and the other half are Kansas residents who hold our professional licenses. Our licensees are also reciprocally licensed in many other states because they have intrastate practices. Members of my board are all professionals. They have learned knowledge in the specific areas that we regulate. The people that we regulate have legal liability for the professional standards of their practice. They can be sued if they are negligent. And we're very particular about the regulations we adopt because we want to only have competent people in the state of Kansas performing those activities. Senate Bill 10 establishes the Right to Living Act, Earn a Living Act. I have 3 issues I want to raise with you about that. And as an analogy, one of the definitions in the Act says the less restrictive restriction. So I'm going to go with the less restrictive problem that I have and go on to the next and the most serious problem I have with the Act. The first one is agencies like mine are supposed to prepare and provide the legislature with a very detailed, comprehensive report about our regulations. Starts out saying we're going to decide what public purpose does it serve? Reasonable. Goes on to say that the report shall be an extremely comprehensive review and is to articulate the health, safety, and welfare objectives to be served by each rule or regulation and articulate the reasons why the rule or regulation serves the public objectives. Okay? Then it says we're to analyze the effects of the rule or regulations on opportunities for workers, on consumer choices and costs, on general unemployment, on market competition, on government costs, and other effects. I don't know what those standards are. I don't know what I'm supposed to report to the legislature, this very broad mandate that's being given to me to determine how it affects each one of those things. And that's every agency in the state of Kansas is supposed to make that analysis and report to the legislature. I think that puts a heavy burden on the agencies, and I don't think it gives them much direction as to what they're specifically supposed to be doing. The second thing, and it kind of ties into my third point, is this act allows anyone, not someone who's got legal standing. I'm an attorney. Usually to bring a lawsuit, you've got to have been affected by a law. This act says anybody can petition a board to challenge any regulation they have, and the board has to explain why it's reasonable and necessary. But even without petitioning the board, they can bring a lawsuit, and they can challenge the rule or regulation in a court in the state of Kansas. And if they win, they get their attorney's fees and costs. What does the board have to do to respond to that lawsuit? The standard is very, very high, and it ties into my third point. If you read subsection D, it says the plaintiff shall prevail if the court finds by a preponderance of evidence that the challenged occupational rule or regulation on its face or in its effect burdens the entry into the profession and occupation. Well, all of these set minimum standards to be able to practice, so there's a burden. You've got to be licensed in order to be an architect or an engineer. Then it says the agency has failed to prove by preponderance of evidence that the challenged occupational rule and regulation is not demonstrably necessary and carefully crafted to fulfill the legitimate public health, safety, and welfare objectives. So we've got to prove that our rule is not trying to protect the public. Doesn't make any sense to me. And then the last point, and this is the most restrictive point and the problem that I have the most with the bill, that the legislative public health and safety welfare objectives can be effectively served by using a less restrictive occupational rule and regulation that is less burdensome to the economic opportunity. As I read this, this sets up a standard for every rule, every regulation affecting every occupation in the state of Kansas. We have to show that our rule is the less restrictive rule possible and the less burdensome on economic opportunity possible. We do things in our agency like determine how many years of supervised experience you need to have before you can be licensed. Reasonable minds can differ on whether you need 2 years of experience or 3 years of experience. How are we going to, and we're stuck for attorney's fees and costs, if anyone can challenge that to determine what is the proper amount of experience that's necessary, what are the proper standards that you have to have. You need to go to an accredited school or a non-accredited school. The laundry list that's in the bill of the definition of less restrictive regulation, I've practiced law for 45 years. I can't understand it. That's all I have.
Okay. We'll hold questions to then. Alexander, is it Bias? Kansas Board of Pharmacy?
Yes, Mr. Chair. Sorry, I'm available remotely, and I hope you can hear me. I think you can. I'm Alexandra Blasi. I'm the Executive Secretary at the Kansas State Board of Pharmacy, and I very much appreciate the opportunity to testify regarding Senate Bill 10 this morning. I'd actually like to start out with something that I didn't include in my testimony, but a thought that I've maybe heard expressed this morning, and just address that. And the Board of Pharmacy, though we may be a part of the executive branch of government, ultimately is formed and serves at the discretion of the Kansas Legislature. And we derive all of our authority, the board derives all of its authority, from the Pharmacy Practice Act, the Prescription Monitoring Program, and the Controlled Substance Act of the state of Kansas. And so, I don't want to give the impression at all that the board is in an adversarial relationship to the legislature. That is not true, and we certainly have the utmost respect for the role that the legislature plays in providing guidance to the board about what our objectives should be and the scope of our authorities should be. And the board takes that role very seriously. And so at the Board of Pharmacy, we do register and license pharmacists, as you might imagine, but we also have students that are attending pharmacy school, as well as pharmacy technicians that are probably a more moderate to low income profession, depending on their level of expertise and experience, that would be impacted by this bill. And I'd also like to point out that the board does, in general, agree with the sentiment behind this bill. We believe that it is important to have a regular review of our regulations. We have set out over the last couple of years to begin a systematic review of all regulations promulgated by the board, which, as I mentioned, do include those under the Pharmacy Act, but also a couple of other acts under the board's jurisdiction. And that process is underway and is moving forward. We've been a little behind because of the pandemic and dealing with some other issues, but we plan to continue. And so I'm intimately familiar with the rulemaking process in the state of Kansas. And one of the things that I will point out about my testimony and where I begin to have some concerns is the timeline that's outlined by the bill. The regulatory process, whether you're making a new regulation, amending a current regulation, or repealing a regulation that no longer needs to be in existence, is actually quite a cumbersome process. And as my testimony outlines, it includes a review by the Division of Budget, a review by the Department of Administration, a review by the Attorney General's Office, a minimum 60-day public comment period, and then a review by the Joint Committee on Administrative Rules and Regulations in that order. The steps of the process cannot overlap. They are one after the other. And so the idea that a review of all of our regulations and changes to such regulations could be accomplished in the timeline set out in the bill, particularly the 90-day timeline, frankly, would be virtually impossible for us to meet. So I simply ask that maybe this committee consider an alternative timeline for a more comprehensive review of all of our regulations. At the Board of Pharmacy, we have 94 administrative regulations, and would be happy to look at those objectively. And as I said, we're already in the process of doing so. So just the timeline would be our primary concern with the way that the process is outlined right now. If, however, we move on, I also want to point out that the board believes that based on just this objective standard of meeting the public health, safety, and welfare standard, all of our occupational registrations and licenses, as well as our rules, meet that requirement. However, the bill sort of takes it one step further. And this is where I say that the sentiment does not necessarily match the black and white that's on the page, because the requirement is that the board meet a very high threshold for what would be a later court review of such regulation. And that strict scrutiny standard, which I'm confident you'll hear more about from some of my other colleagues that may be speaking today, would be our primary concern, because we believe that though our regulations are designed primarily to protect the public health and safety, in fact, most of the board's regulations are practice oriented. They are not just administrative in nature. this is an exceptionally high standard to meet, and we would truly struggle to meet that standard, even for our pharmacy practice regulations. In addition to that, I agree very much with Mr. Karn's assessment of the petition and court filing option. We do believe that this would open the floodgates for individuals, whether they're licensees or impacted by the regulation or not, to file petitions with the board for review of these regulations. And a couple of things that I'll point out. Nothing in the bill indicates that the board can meet that requirement for responding to a petition once for a regulation, and then it's kind of a one and done thing. There would be nothing from even the same individual continuing to file petition after petition requesting the board's review of those regulations time and again. And obviously that creates really waste and unnecessary response when the board maybe has already made such a conclusion. Nor does it allow the board to prevent any petitions from being proactively filed, concluding that the regulation is necessary to fulfill the legitimate public interest. And again, the timeline here with the 90 days would be very difficult to meet that requirement, especially because the board generally meets only every 2 to 3 months. So gathering them, there is cost involved in having board meetings. And though the pandemic has allowed us to meet virtually and create some efficiencies that had not previously existed, there are still challenges in gathering a 7-member board that is a group of professionals that is involved in the practice of pharmacy on a regular basis. In addition to that, with the court filings, I would just iterate the same concerns that the actions would be able to be filed by any individual, and the board would have to provide resources to support any and all court filings, and then continue to participate in that litigation up through the Supreme Court level if that was challenged. And in addition, would then be responsible for any attorney's fees and the costs if an individual did prevail in that litigation. And I appreciate the time constraints today, and so I'll stop there and be happy to stand for any questions at the appropriate time. Thank you, Mr. Chair.
Thank you. We'll hold the questions. I do have a couple of the presentations I had up today. We might have to have the lid come back. Is that all right, Eric? We can I think we can fit the housing in. How much time? I wonder, Ryan, do you know how much time you'll need? He's not in. Let's go for about another 10 minutes with the proponents, and about 35 after, we're going to go to questions, and we're going to wrap up the last 15 or 20 minutes for the Housing Authority, okay, on this bill. So let's move on to David Hoffman. So the next 3 will have the total of 10 minutes, and then we're going to go to questions.
Thank you. Can you hear me okay?
Yep, we can hear you.
Okay. Good morning, members of the committee. My name is David Hoffman, testifying in opposition to SB 10 in several capacities. First, I'm a practicing Kansas architect in Wichita, Kansas, licensed for 46 years and licensed in 28 other jurisdictions, including the District of Columbia. Second, I've served on the Kansas Board of Technical Professions, being reappointed for 3 4-year terms, and served in all elected board positions, including the chair of the board, the chair of the Architect, Landscape Architect, and Geologist Committee, and chair of the Disciplinary Committee. Third, I've been a member of the American Institute of Architects Kansas chapter, a professional organization representing over 740 architects, for 43 years, and served in several capacities, including the state chapter president, as well as on the National Board of Directors. Fourth, and probably most cogent to the consideration of SB 10, I recently completed volunteering 8 years on the National Council of Architectural Registration Boards Board of Directors, serving as its national president in 2019. I've been immersed in the regulation of the architectural profession in multiple ways for the past several decades. So speaking from an architect's perspective, I have the following observations concerning SB 10. First, the terms occupation and profession are used interchangeably throughout the bill. However, there is a significant difference between these two terms. Professionals must satisfy a recognized regimen of accredited university education, satisfactory mentored experience, and they must qualify for and pass a jurisdictionally recognized psychometrically valid examination or series of examinations to confirm competence. The potential for catastrophic harm to the public's health, safety, and welfare serves as the clear and rational motivation for the licensing of architects. Architectural practice is not merely an occupation. 2, simply put, the general intent of this bill is to remove or lower perceived regulatory barriers to entry for all vocations, occupations, professions, jobs, or any other term that you care to use. This bill is aspirational in nature. Section 1C4 is a prioritized list, modified somewhat from the Institute for Justice's upside-down pyramid, showing the Institute's recommended level of regulation from least to most regulated. As you are aware, the Institute of Justice is a law firm based in Arlington, Virginia, attempting to promote the restriction of state regulatory legislation on a national scale. There is no doubt where this list came from. It is not original to the bill sponsors. The intent of the list is clear and could be a basis for policy, but is not sufficiently defined to be able to be written into law as a standard. It is too vague and does not serve as a rigorous benchmark against which the Board of Technical Professions can realistically comply with the requirements listed later in the bill. 3, Section 2A limits all rules and regulations to those demonstrably necessary and carefully promulgated to fulfill legitimate public health, safety, and or welfare objectives. Conceptually, it sounds good, but functionally and pragmatically, it will be a nightmare to respond to, and certainly is not a clear standard that can be met as required by the next section, 2B4. For the architectural profession, this process of careful promulgation and demonstrably necessary regulation has been underway since 1919 when the National Council of Architectural Registration Boards was founded.
You can sum up, Doug, David. I've got 2 other people that want to testify. I hate to put you in a time crunch, but we just
Well,
don't
I
have
do
enough
certainly
time.
have 3 or 4 more points, and they essentially come down to the fact that for the architectural profession, we have installed and in place a functioning system that re-examines the process that you're trying to do, and we do re-examine ourselves on a yearly basis, and the revisiting of these regulations and reporting on a yearly basis is going to be very expensive, and it's going to be burdensome on the Board of Technical Professions. At essence, the architectural profession really does not fall under this, the auspices of this proposed SB 10.
Okay. We'll go ahead and move on to Trey. Is it Cocking?
Good morning, Trey Cocking. I'm the Deputy Director with the League of Kansas Municipalities. Thank you for being here. This is a very broad bill. It includes us, and it has us make our report to the legislature. You know, we think our governing bodies are always empowered to make the best decisions for their communities. And I will tell you, when it comes to business licenses, cities are already very competitive. They compete with each other. So they don't want to do something to put themselves at a competitive disadvantage with these licenses. But I will tell you a story of where it has worked, and that's with massage licenses. We had a big problem probably 10 years ago with human trafficking, indentured servants, and so we had cities that started regulating massage therapists because the state wasn't. We were able to take care of a lot of that, prostitution involved with that as well, and we were able to quickly deal with that. I don't know if you guys remember, but 2 years ago we had a situation just like that 2 blocks away from the Capitol. So it makes sense for cities to quickly act. It makes sense for governing bodies to review it. And then the last thing I'll tell you that I'm really concerned about with this bill, I almost call it a offer full employment of attorneys because of the cause of action that it creates that puts you in court. It doesn't even cause them to go to city council and say, hey, I don't like this rules and regulation, they run straight to the courthouse, which causes us a lot of concerns with this bill, sir.
Me as the chairman, I definitely see the bill way too broad, and if it ever moved, it'd take a lot of work to get it right. I definitely agree with that, and sometimes, you know, I didn't think much about it. I had 2 other presentations today, and I thought, I'll throw this on there. Probably should have had its own couple days to hear everybody. But if this would to move forward, we're gonna have to do considerable work. And I get that. So, you know, sometimes that's what happens, you know.
I appreciate it, sir. Thank you.
Thank you. Okay, we'll move on. Rochelle Colombo. Rochelle? Okay, I don't hear, she might not be here. I see written. Okay, the rest is written only. Questions for the opponents? Go ahead. Did you want to testify? Okay. What's your name?
Tucker Poling.
Okay.
I'm the Executive Director of the Kansas State Board of Healing Arts.
Okay.
With your permission, Mr. Chairman,
Go ahead.
I will make some brief comments. Hopefully you have my written testimony.
We got a stack of it here, so I'm guessing we do.
Okay. So I won't repeat what's in there. Our board licenses and regulates over 32,000 healthcare professionals in the state of Kansas from 15 different healthcare professions. We license and regulate the people who literally hold the life and health of Kansans in their hand every day. We think that that's vitally important work. My board is composed of 15 members, 12 of whom are licensed healthcare professionals themselves, many of whom are business owners. I assure you that my board is not interested in promulgating a lot of unnecessary, overly burdensome regulations. My board members serve on the board because they're motivated by a passion for our statutory duty, which is public protection. And that means that when a Kansan walks into their healthcare provider's office, they can rest assured that that healthcare provider has been held to quality and safety standards and ongoing quality and safety standards, and not just the lowest and least restrictive possible quality and safety standards that we can possibly come up with. That's what our mission is. And so my board members are not enthusiastic about the idea of engaging in a race to the bottom to determine the lowest, least restrictive quality and safety standards we can come up with. And that brings me to one of the core points I wanted to make. And it was raised in part by Mr. Carnes, and I believe a couple others. There's been a lot of discussion about this bill that really kind of focuses on the report process in Section 2. The real problem is Section 3, and that's, I would agree, the litigation factory in Section 3. Section 3, and most specifically at D2, sets up a strict scrutiny standard. And as an attorney, I see that, and that's a standard that is exceedingly difficult to meet for any law or regulation to survive. I heard this term may be familiar to legislators. It was discussed a lot in the context of the Value Them Both Amendment. I heard a Catholic law professor give some testimony on that strict scrutiny standard and how difficult it is to meet. That's there in D2. And that sets up a litigation process by which any plaintiff's attorney can file a lawsuit, and it would be very difficult for any quality and safety regulation to be upheld, because that elevates the standards that others were talking about to something completely different. And I want to say on that point, we already have a process by which people can challenge our regulations in court. And I've cited that in my written testimony. It's in the Kansas Judicial Review Act. If anyone can challenge any one of our regulations, and if a court finds the regulation to be unreasonable, they can strike it down. So there is that remedy available in existing law. There's no need to create this litigation factory in Section 3. Now, that said, we do like, one of the concepts that we like in this bill is the idea of creating a process by which these regulations can be regularly reviewed, and a process by which There is a report to the legislature. Most specifically, we would like a process by which we can report to the legislature statutory changes that could be made to allow us to revise and eliminate some of the regulations that we no longer feel are necessary. That is valuable, because a key point here is the problem with this bill is it kind of shifts what is a legislative issue at its core, and it puts all of the burden on the administrative agencies, subjects us to litigation, attorneys' fees, and there's really no corresponding responsibility from the legislature. Every regulation we promulgate comes from the authority that you all provide, the legislature provides in your enabling clauses and the statutes that you pass. A lot of those are mandatory, that we have to promulgate these regulations. I gave an example yesterday in committee on SB 34 of a regulation I've been trying to cut down for a couple of years from 6 pages down to 1. And the problem is the enabling statute is causing problems, that we're not able to cut it down as much as we'd like. So, you know, we would respectfully suggest that instead of creating a new civil right, a new source of litigation to address all these issues on the back end, look at the issue at the statutory roots, the enabling clauses. I know that's potentially a more in-depth process. You know, it's not maybe as superficially attractive as just passing one bill, but we think that would be the more appropriate and responsible approach. And we want to help with that. Because there are regulations that we would like help updating.
I think
statutory changes is needed.
I don't want to speak for the makers of the bill. My guess is they were probably, remember a few years ago we had the Office of the Repealer. They were probably thinking the same thing about some of the rules and some of the licensing that's been on the statute book for a long time. And I bet you if we look, there's probably several of them we need to probably get rid of. And I think, I don't want to put words in their mouth. This was their avenue of trying to eliminate some of them. You know, I'm sure there's probably, and build a more modern structure than what we've had over the years. That's my guess. But like I said, we've got work to do for this bill if it's going to come out. And we will.
Happy to stand for any questions at the appropriate time.
Go ahead.
Michelle Meyer with the Commission on Peace Officer Standards and Training, and I also submitted written testimony and submitted to be here in person as well. I'll be very brief. We regulate all law enforcement officers in Kansas. Again, I understand the intent of this bill. This exact model legislation has been introduced in a number of states, and from the research I've done, no state has passed this out like it's written right now. What most states are doing is what's sort of been brought up as having a broader commission or a broader legislative committee that looks individually at all the licensing agencies. And, you know, a law enforcement officer may fall into this category of lower income, but they're very different. There's no other occupation that you have the ability to take a life, save a life in the scope of your duties all in one day. All of the legislation that has been introduced almost uniformly, law enforcement is exempted from that in other states. That includes Michigan, Florida, Mississippi, Utah, Wisconsin, Indiana, Louisiana, Arizona, Oklahoma, Missouri, Pennsylvania. Those are all states that have introduced broad legislative licensing regulations and have exempted law enforcement because they're so different. So that's what I'd be asking in this case. I do know that we worked with you on a lot of these bills in the past. We would just ask that we would be included in any conversations like that, and that there would be an opportunity to preserve. I expected to be in the legislature a lot this year because of all the police reform that's been discussed and that may be introduced, and instead this is the third time in less than 3 weeks that we're testifying on licensing bills. And so we would welcome in some sort of broader scope that we can individually address how different our agencies are. You know, if this bill is intended for the hairdressers and the dog walkers, then I think it needs to be directed at those. And then we can look at law enforcement differently. We can look at medical differently.
I think if the bill moves forward, it would, you were around a few years ago when we did the other, it would probably start at that place. Discussion would start and, you know, with everybody in the room, where we can talk more freer and probably migrate to the low-hanging fruit.
We appreciated that work with you, and we would just welcome that as well. Thank you.
Okay, thank you. Questions or comments? Wow. They're all out of questions. Okay, are there any neutrals? Not seeing any. We will close the hearing on Senate Bill 10, and we will move on to Ryan Vincent with the Kansas Housing Resource Center. You want to pass them out? He's going to do a presentation. Thanks, everybody, for coming or giving testimony.